Good morning.
Good morning.
Good morning.
If you're ready. Good morning. My name is Nevin Weidner. I represent the appellant in this case. I would like to reserve 5 minutes of my time for rebuttal.
Sure.
The facts in this case are actually very straightforward and quite simple. My client, Scott Kunzman, was a highway patrol trooper who was terminated allegedly for misconduct in office and also for perjury, and was given a notice letter notifying him of his immediate termination on November 7th, 2012. He filed, or attempted to file, an appeal with the PERC that was done by letter dated November 26, 2012, and was mailed to PERC. PERC took the position, the Department of Safety and
Highway Safety
and Motor Vehicles took the position that it was untimely because it arrived 1 day late. The hearing officer recommended that it be dismissed, and it was dismissed without a hearing, and so this appeal follows. The basis of the claim is that doctrines of equitable estoppel and or equitable tolling require that the appeal go forward, that Trooper Kunzman's appeal be heard by PERC instead of just simply dismissed for having arrived evidently 1 day late. The letter that was given to Trooper Kunzman notifying him of his termination and his rights to appeal expressly said, if you intend to appeal the action to PERC, you should complete and mail the attached appeal form to the commission.
And if I may, Mr. Weidner,
yes.
In this case, that was not done. I mean, the actual attachment to mail it, that was not done in this case. Instead, I think you prepared a letter on behalf of your client indicating that you wish to appeal, correct?
Correct. It's because the notice that was furnished to Trooper Kunzman did not contain any form or probable cause affidavit or anything. It was simply the termination notice.
Okay, because I'm looking at the actual termination letter right now, and basically the subset, it's under appeal rights, under Roman numeral 2. It says that if you intend to appeal this action, you should complete and mail the attached appeal form to the commission. That's one sentence. And this, we know that was not done. Then you look at the next sentence, and it advises your client that Florida statutes requires written notice of the appeal, and here's the operative language, must be filed with PERC within 21 calendar days.
Yes,
and
ma'am.
it says that. Then later on, and it says, what does filed mean? It means that PERC receives written notice of appeal. So how can this be an equitable estoppel language if it's pretty clear that delineates the time period that's involved?
Well, it does, but the ambiguity I submit that arises is the instruction to mail the appeal. And the appeal was mailed in a timely manner, and under the Pat's decision, it could have been regarded and reasonable to expect that it would have arrived in a timely manner before the expiration of the 21-day period.
So you don't read the mail, the attached appeal form that it's referencing to that form itself that's attached, and you said that you indicated earlier that was not.
It's, you know, when you get these notices and they're incomplete, it's difficult to try to ascertain who it is you're supposed to contact in order to get the proper forms in trying to deal with the motor vehicle.
Did you try to contact someone to get the proper form, or did you just send a letter?
I just simply sent the letter. I did not.
Because the letter, the notice references a form and a deadline,
Yes.
neither of which occurred.
Yes.
The form wasn't sent and the deadline wasn't met.
Correct. That's true, yes. And I will confess that I was not aware of the distinction that I'm now aware of between filing and mailing, even though this letter says what it says in terms of its having to be received.
Does the Mashulis case help you?
Oh, I believe it does in its recognition of equitable tolling. I think it does. The fact that it ought to be applied, and I guess the question I would ask this court is, when does equitable tolling or equitable estoppel apply if this deadline, this 21-day deadline, is deemed to be so rigid that no circumstance, such as a misunderstanding or a misleading, ambiguous instruction, could be considered to have contributed to the delay? And
Well, for example, if you want to look at equities, had the proper form been mailed, 15 days from the deadline, that may be different than the improper form being mailed a day or two before the deadline,
well, yes,
because we're talking about equity.
okay. I mean, that obviously would
So
make
you have
things.
kind of the double whammy going on. It missed the deadline and it wasn't right when it got there.
I agree, there's a sliding scale here in terms of the timing of it. I understand your point, Your Honor. In this particular case, Mr. Kunzman, there's a humanity involved in this. Mr. Kunzman was shocked by this. And so when I sent the letter to him for review and for his signing, there was just he's dealing with all kinds of issues. He's lost his job, his income, there's family issues, there's everything associated with that. He simply didn't respond as quickly as I would have liked him to, but he didn't. And when I got the letter, that's why it's crossed through. The date has changed from crossed through, I think it said November 12th, but it's crossed through and said November 26th. It's because that's the date I received it back from Mr. Kunzman, Trooper Kunzman. I did not appreciate, I confess, I did not appreciate, this should go up on Federal Express or overnight mail or some other form or fax or something, because I looked at the letter and said it should be mailed. All right, I mailed it. And I was not aware of, and I was not an expert in these issues, and so we missed the deadline by a single day. I would submit that, nonetheless, standards of equity and equitable tolling, equitable estoppel, and the principle of equitable tolling that's embodied in the statute should apply in these cases, and that it is overly harsh and overly rigid to simply say a one-day delay without any claim of prejudice ruins someone's consideration on an appeal.
Let me ask you a question, Mr. And let me follow up with that.
Sure.
Because our standard of review, as I understand it, first of all, we can't really substitute our judgment from what they've done. We have to look to see whether or not there was competent, substantial evidence to support that. And in terms of equity, as I understand that case, the case that you indicated supporting your position, that case, as I read it, is a little bit different. In that case, the actual parties participated, even though it was after the deadline. There was a lot of participation by the other side.
Sure.
And so later on, they're like, oops, it's beyond the time. And the court rightfully say, no, you can't have it both ways. You can't allow someone participating in the litigation. Later on, you say, gotcha, you cannot do that. Are you asking us to basically say, your department, we're now substituting our judgment? No, it's only a day, let it slide.
I'm not simply asking the court to substitute its judgment. I'm asking the court to recognize that the instruction to mail is what led to some confusion, reasonable confusion, for somebody who's inexperienced, such as Trooper Kunzman and myself and many lawyers. It leads to an ambiguity that is not clear, and that ambiguity was created by the department's notice letter. And so given that fact, it's not the same thing as the Machuli's facts. I do agree with that. But just that simple fact alone, the fact that the department contributed to the confusion, even though there's other language it cites to say, well, there should not have been any confusion, I would submit that that's a position to be argued, but I don't think one can summarily conclude that automatically. And there was no hearing held here, and there was just no opportunity to explain that we never got any of the forms that were attached. We just got the form, the notice letter itself. I would believe, and I'm not disagreeing that there is some fault on my part, but I do think that in part the agency contributed to the misunderstanding. And for that simple reason, particularly because there's no prejudice, you shouldn't deny somebody their day in an administrative hearing. It's just, it's so, and the rule that's been adopted does not find its statutory counterpart. It's not as if the statute says. The statute doesn't define filing. It does say that appeals should be filed, but it does not define what is meant by filing. As I'm sure most lawyers and judges know, and if you're not an expert in this administrative law area, normally a filing is regarded as when it's posted in the mail for most decisions. Especially when you've been given a notice, which is what was the case here, from the department terminating Trooper Kunzman, And then the response was mailed back. I was perhaps incorrect in believing those civil rules of procedure and that standard pertained, but when I read the letter, I said, well, it has to be mailed, let's get it out. Should be up there in the 2 days. And I think the lack of prejudice is something this court shouldn't just facilely overlook and simply say, oh, we're substituting our judgment. The standard of equity, applicable both in tolling or estoppel, requires the court to consider these equities. The court's supposed to do that. And the agency here believes it doesn't have the authority to. It takes that position, which I would submit, at least on the part of the Department of Highway Safety and Motor Vehicles, may be a self-serving one in this case. But PERC took the same position that simply said, oh, it's automatic, it's just strict, there's no flexibility, and none was applied or has been bestowed. And that standard can continue, or I think more rightfully, the court ought to articulate that when you're considering equitable tolling, which the statute says is something that needs to be, that deserves to be considered, that these things should be regarded on a scale to try to determine, is there harm, is there prejudice, is there just absolute neglect on the part of my client. It's only 1 day late. We mailed it within the applicable period. It's not like we waited 6 months or 3 months or anything like that. And I think those are the kind of standards that the statute is designed to empower the court and the agency, or PERC in this case, to consider. But that was not done. And it's done because there are decisions, precedent, which seems to say, oh, we don't consider those. I'm disappointed when I did the research to learn that seems to have been the evolution of the standard in this area of the law. It doesn't seem to me it's a sound one, and one that's fair, comports with what's really justice in America. To me, it's like saying, oh, we're not going to look at the package, we're looking at the wrapping. And the wrapping doesn't meet our standard, therefore, no day in court. And I submit that this court has the authority, and in equity has the duty, to say, look, we need to revisit some of the articulation of the earlier cases, or the application of the earlier cases, and to recognize that there is a equitable standard that can apply. And in this case, the distinguishing feature, unlike any of the cases cited by the Department of Motor Vehicles and Highway Safety, none of those cases say mail the application. That is the linchpin in this case that I think allows this court to recognize a distinction and to say, in this case, for some reason, I don't know why, they chose to say you should mail this application. That's what they chose to say. Who knows why they did that? But having done that, they ought to have some responsibility for understandable confusion that can occur when people are not as expert as they are in establishing the standards for which, by which an appeal should be filed and can be prosecuted. And unless there are other questions, I won't beg the issue any more than that. Thank you, Mr. Weidner.
Thank you.
May it please the Court, Charlene Kai Patterson, Assistant General Counsel for the Department of Highway Safety and Motor Vehicles. Because equitable tolling provides no exceptions in this case, this Court must affirm the Commission's final order dismissing Mr. Kuntzman's appeal as untimely. Just to start off, it's the Department's position that the attachments that were identified in the notice of dismissal were actually included and given to Mr. Kuntzman. There is no sworn affidavits in the record regarding that information not being received. There's a verification of some sort in the record at the close of the opposition for the motion to dismiss, but without any sworn affidavits, I don't think there's any reason that an evidentiary hearing would have been held in order to attest to that. The statutory requirements in this case are clear. Section 110.227 sub 5 sub A requires that the appeal be filed with the agency within 21 days of receipt. Mr. Kuntzman, as you know, received his notice of action on November 7th, which made his appeal that was received on the 29th untimely. Specifically to this case, Section 110.227(5)(b), which addresses extraordinary dismissal, the notice would have started from the actual date that it was received. So where Mr. Kunzman argues that because he was not actually dismissed until November 8th effectively, has no merit in this case. In Savar Creeks versus Florida Fish and Wildlife Conservatory Commission, which is the first DCA case from 2013, final agency action was determined to have occurred when the agency binds itself to a course of action in such a way that the other party is prevented from protecting his or her interests at a later time. And so the agency took its position, reduced it to writing, and disseminated that information to Mr. Kunzman. In addition, Section 120.569 sub 2C requires that an appeal received outside of the 21 days must be dismissed. And that statute, along with the uniform rules, which the Commission also has to go by, which is 28-106.111 sub 4, provides that equitable tolling is the only defense to an untimely filed appeal. And in this case, Mr. Kunzman cannot sustain a claim for equitable tolling under Machules because he doesn't meet any of those three requirements. He was not misled or lulled into inaction by the agency. He wasn't precluded from filing by some extraordinary action, and he didn't timely file in the wrong venue. And so the agency did not mislead Mr. Kunzman or lull him into inaction. The letter in and of itself was very specific, as Your Honor pointed out. It did say to complete and mail the attached appeal, but it said specifically that it had to be mailed within the 21 days and that it had to be filed with the Commission, and it also defined filing as when the Commission receives the appeal in their office. It also, in the letter itself, cited to Chapter 110, and so counsel would have been aware of where he could have gone in the statutes in order to get clarification if there was any type of confusion. And although Mr. Kunzman and maybe his counsel may have been confused as to the law was not confusing in existence. An inadvertence or mistake of counsel or ignorance of the rules should not translate into misleading Mr. Kunzman. There's nothing in the letter of any of the attachments that would support that Mr. Kunzman was led into believing that simply mailing the form or that the form was postmarked within 21 days was sufficient. I think maybe from possibly the lack of experience in dealing with the administrative realm that opposing counsel was relying on the rules of civil procedure, which we know do not apply in administrative cases. And finally, it's really just, it's not reasonable that Mr. Kunzman can actually argue that the agency forced him to waive his right by informing him to mail the appeal when he didn't continue on with the rest of the sentence, which was to mail it within the 21 days and to actually send the appeal itself. Counsel sent an actual letter, so if he was really sticking to the letter, for lack of a better term, of what the agency was, how the agency may have been misleading him, he would have actually gone on to try and find that appeal form and send that appeal form in because he felt that it was actually required, as was the mailing. If there are no questions, I think that's really all I have.
Okay, thank you, Ms. Patterson.
Thank you.
I will be brief.
Okay.
Three things. Equitable tolling is applicable in this case, both by statute 120.569(2)(c) and by rule 28.106-111 expressly makes equitable tolling applicable. So the argument that it doesn't apply, to me, I have to admit I don't understand that. Whether the facts justify its application is the issue. And in this case, given what I've described as the singular statement that the application has to be mailed, I would submit that that should justify the application of equitable tolling. The other point I would make is that the instruction to mail it, to me, allows the conception to be that the point of entry in this process, notwithstanding the language that says it has to be received, is by mailing it with the U.S. Postal Service. That's what the instruction said. Finally, the steps that I could have taken, should have taken, coulda, woulda, shoulda, in hindsight, I'm not arguing that those were not steps that coulda, woulda, shoulda been taken. But my failure to take those steps do not alleviate the misstep of the agency in not providing the right form immediately and in stating that it was supposed to be mailed. So it's a combination of factors. But unless equity is allowed to reinstate the appeal, my client's missteps or my own missteps get punished. The agency's own missteps, they get exonerated for that. And that's not what equity is supposed to be about. And I'm not trying to condemn or make rash overstatements against the agency. I'm simply trying to recognize that this is why confusion can occur. This is how it occurs in real life. And to now be lawyeristic is not what equity is supposed to be. It's not what the point of the APA is supposed to be all about. It's supposed to afford persons an opportunity for their form of justice. And Trooper Kunzman doesn't have that. And he should. Thank you.
Thank you, Mr. Weidner. Thank you both. Last case on the docket is Ronald Waller versus Tandy Loan Co.